Justice Abhay Thipsay, a former judge of the Bombay High Court who ruled on 4 bail applications in the Sohrabuddin Sheikh encounter case, says there is a need to relook at how so many accused in the case were discharged. Speaking to NDTV's Sohrabuddin, Justice Thipsay has said that if wrong discharge orders were passed, it could be a miscarriage of justice. After Sohrabuddin's death in 2005, the Gujarat anti-terror squad had said that he was a terrorist who planned to assassinate Prime Minister Modi, who was Chief Minister of Gujarat at that time. But later, a CID probe had shown that it was actually a fake encounter.
Sir, I'd like to ask you, the first question is there a need for a relook, as you've said, in the way that this trial has progressed?
Yes, certainly there is a need to relook at the trial because there are many aspects which are uncommon and therefore it needs to be examined by the appropriate court, that is Superior Court, which is the High Court.
Sir, more importantly, the questions you've raised on the discharge of several top police officers, especially in this case, and several high-profile discharges that have taken place. What are the specific concerns that you have, specifically looking at the law part of it, as far as these discharges go? Because you've called it that it could be seen as a miscarriage of justice.
Yes, I do think that if the wrong discharge orders are passed, it would be a miscarriage of justice because ultimately a person may be acquitted, but when you discharge a person, you say that there is no sufficient material against him to proceed. Means you don't even frame charge. Means the grounds are not there to go ahead with the trial also, which happens very rarely.
So you would say then there are inconsistencies in the orders of the special CBI court. Am I quoting you correct on that?
Yes, I think so. Because, first of all, they are inconsistent with the observations made by the superior courts while dealing with the bail applications. So those reasons should at least be considered by the trial court, which does not seem to have been done. Then secondly, inconsistencies are this way also. Particular material is said to be unbelievable, but based on that material only you are proceeding against some other accused. So you are creating some sort of a strange theory that this happened, but this happened at the instance of subordinate officers only. That sort of theory you are creating, which is very difficult to digest.